Hello, hi, let's start this lecture then. As usual, we will start with a short revision of last week's lecture. So, last week we were talking about consumer protection and we were comparing it to the protection under the general provisions of Civil Code. And we were talking about mistaken belief, in Japanese, gonin. And we were also talking about distress, in Japanese, konmaku. We were saying that mistaken belief, gonin, does not fulfill the criteria for fraud. So usually it's not fraud under the Civil Code, but here we also need protection. So we have these three categories: misrepresentation, fujitsukofuchi, provision of conclusive evaluations, 断定的判断の提供, and omission of disadvantageous facts, 不利益事実の告知. And as you remember, I told you, if you want to remember these three categories, you will think of an old boyfriend or girlfriend in the past who was not so good. So he or she was telling one, lies, two, saying that he or she is 100% sure about something which will happen in the future, although nobody can be absolutely sure. And number three, he or she was not telling you the bad things, just giving you only the good information. Three categories. And we were also talking about distress, konwaku. We said that it does not fulfill the criteria for duress under the Civil Code. But here we also need protection. Two types, failure to leave and preventing a consumer from leaving. Here again, I told you that it's easier for you to remember this if you think of not an old boyfriend or girlfriend, but a future boyfriend or girlfriend who is telling you, I'm not leaving tonight, or you're not leaving tonight, 1 and 2 respectively. Now, we stopped here. So we said that mistaken belief and distress have to do with the phase where you're still negotiating the contract. Once you conclude the contract, you have the regulation of its content, which means that the conclusion procedure was fine, but the content is not good. So there are three provisions you can use from the Consumer Contract Act. The first, please have a look at last week's resume, which I don't have and which doesn't exist there anymore, but we'll manage to do something, I guess. So, if you have a look at Article 8, please have a look at its content. Quick look. It talks about the nullity of clauses which exempt a business operator from liability for damages. What's that? I gave you one simple example. You go to a fitness club and you find a sign saying, we don't bear responsibility whatever happens to you or your belongings. Is that valid or invalid? You can find the answer in the provision if you read the provision of Article 8. Please have a look at Article 9. It says nullity of clauses that stipulate the amount of damages to be paid by consumers. I gave you two examples. Sorry, I gave you one example and I will give you an additional example too. The example I gave you was that of university fee lawsuits. There was a series of lawsuits against some famous private universities because, as I told you in the past, most private universities would say, once you pay the fees, entrance fees and tuition fees, we don't give you anything back because that's our policy. So, according to the Supreme Court, yes, regarding entrance fees, that clause is valid. But regarding tuition fees, it's not valid. And according to the Supreme Court, it has to do with the date when you cancel your entrance to the university. If it's on March 31st or before, there is no damage to the university. If it's on April 1st or after, there is some damage to the university. The second example, which I did not give you last week, but it's more familiar to you, is that of the mobile contracts. I have an iPhone, a contract of 2 years with a certain famous company, which uses a white dog for its advertisements. And they told me that this is for 2 years, so you will pay less, but if you choose to cancel your contract during this period, you have to pay a certain amount as a penalty. So, a series of lawsuits again against these clauses. In short, the court said, oh, that's valid, even if judged under the Consumer Contracts Act. Again, in these lawsuits, they used Article 9. And finally, please have a look at Article 10. This is the general provision. Even if a clause is valid under Article 8, valid under Article 9, we still have Article 10. And as I told you, the representative lawsuits regarding Article 10 were those having to do with key money, deposits, and renewal fees. Regarding deposits, the issue was that normally they have to give you back the remaining after they deduct the amount which is necessary to restore the house in its previous situation, etc. But usually they just set a fixed amount and they just tell you, we are not going to return you this amount, whatever the situation is. In short, according to the Supreme Court decisions, there is no issue with such provisions regarding deposits and renewal fees. Of course, if the amount is extraordinary, there might be an issue, but in general, these clauses are valid even under Article 10 of the Consumer Contract Act. There is no decision regarding key money, of the Supreme Court. But in general, it is also considered to be a legal practice, again, as long as the amount is not extraordinary, etc. Any questions regarding the previous lecture? No questions. So, let's move to today's lecture. Today, we will talk about money lending. And if you check our syllabus, you will see that from today we start with a new series. So it will be something which has to do with daily disputes in Japan, etc. Who would like to read? So if you check today's material, you will see that the last 2 pages are copies from the book. Who would like to read the first page? Okay, so let's start with Chisaki and we move to Makoto. Half and half, you decide which half. So let's say that it's a pizza and you decide which half you would like to eat. It's the same pizza, no different in flavor. Okay, so you start. Oh, sorry, you need the microphone. Yes, the page about that suicide. Oh, the previous page is also interesting. So please have a look at page the page which says conclusion, let me read that part. It says, "Why does Daddy have to work so late?" Wow. So you see, it's quite interesting. But let's move to dead suicide. So please read the first half.
Okay. On a cold night in February 2003, Kazuyoshi Saito stood on the platform of the Utsunomiya line waiting for the next express train. He knew the schedule precisely, and he also knew that the train did not stop at that station. His intent on this night, as on the two previous occasions that he had come to the station, was to gauge precisely when he should jump in front of the speeding train in order to maximize his chances of death and minimize his chances of merely being injured. Doing so, he reasoned, would be the best way to relieve himself of the $300,000 in debt that he had incurred in the past decade, a debt that his annual income of $30,000 was unlikely to wipe out anytime soon. Having confirmed his timing calculations, he stopped by a local convenience store, bought a newspaper and a bottle of whiskey, and returned to his cluttered apartment. The rent for...
Maybe you could change now, because I will leave this page. You will change mine. Thank you.
The rent for which he had not paid in 4 months. In the newspaper, he read for the first time stories about a new legal process called civil rehabilitation. He had heard of it before, but had not followed the news closely enough to know much about it. His problems were bigger than that. But as he read, he learned of debtors who had chosen the new process as an alternative to bankruptcy. He had never considered himself a candidate for bankruptcy. That would only make his life more miserable, and it was miserable enough as it was. But civil rehabilitation sounded more appealing, and he didn't think that his neighbors and friends, or at least those who still remained, would shun him as they might had he filed for bankruptcy.
Thank you. So, this is a small part from this book written by Mark West. He is a professor in the United States, but he was also in Japan. He was in Kyoto University for research some years ago. The book is called Law in Everyday Japan, very interesting. The subtitle is also interesting, Sex, Sumo, Suicide, and Statutes. So we have 4 words starting from S. I don't think he means that these are the 4 words that represent Japan, okay? But if you read the book, it also mentions about, it's a book about law in everyday Japan. So he talks about the legislation regarding love hotels, legislation regarding sumo, suicide, etc. It's quite interesting. So, as you saw in this part, 2003, so it's 14 years ago, it was the period where we were having in Japan a lot of suicides because of death. So, who would like to continue reading the next paragraph? Okay, Lily, please, and then we move to Enzo, okay?
The following day, instead of jumping in front of the train according to his original plan, he contacted the lawyer. He soon filed for civil rehabilitation and sought psychological counseling at the urging of his attorney, and he gave up thoughts of suicide. Sadly, many debtors in Japan jump. In 2003, 34,427 Japanese committed suicide, about 94 per day, a figure that, as we will see below, is high by international standards. Of these, 10,387 left suicide notes. Police who investigate the suicides divide the notes by category based on the primary reason for suicide mentioned in the notes. The largest group, 3,890 victims, claimed that health problems were the cause. The second largest group, 3,654 victims, or about 10 per day for a country with a population half that of the United States, explicitly blamed economic factors as the primary motivation. If the percentage of those who cite economic factors for their suicide is the same among the victims who do not leave notes, the number of such victims would reach 33 per day. 33 people killing themselves every day because of the economy. And the number of unsuccessful attempts is estimated to be 10 times the number of completions.
Thank you, and could you pass the microphone to Enzo? The last paragraph for today. Thank you. So Enzo, maybe next time you could sit. Because they usually raise their hands, so you will need to walk every time.
Yeah, I understand.
Stories about these step suicide victims have appeared with increased frequency. Japanese morning-wide news variety television shows, Waido, feature family members of deep suicide victims telling sad tales with follow-ups from reporters telling the next potential victims. You don't have to die, in the 2002 report in the New York Times, noting that as many as 2 million Japanese are effectively bankrupt, finds that statistics are skewed because every year, thousands of people in distress commit suicide. Police statistics show rather than face the debt collectors, friends, and families in shame. The Minister of the Economy blames the system for the high number of debt-caused suicide in Japan, calling it unimaginable in the West, where businesses are allowed to fail yet people make a fresh start on life.
Thank you. So, why did I show you this? Because today you will not find such a large social issue regarding deaths and suicides in Japan. Why is that? Because legislation has become better. But in order to understand and appreciate today's legislation, we need to know how the situation was in the past. So, before entering into the legislative part, this is the last part from the same book. Who would like to read this again? Eliko, please.
In the summer of 2003, 3 Osaka residents, a 61-year-old cleaning company worker, his 69-year-old wife, and her 81-year-old brother leapt in front of an oncoming train on Japan Railway's Kansai line to their deaths. The suicide note sent by the wife to her friend explained why. According to the 4-page letter, the husband had borrowed $200 from various sources. The amount to be repaid now totaled $1,500. Debt collectors called the house every night, and when the couple said that they could not pay, the less savory ones threatened to get it from their neighbors. She concluded, we have decided to apologize with our lives.
Thank you, because so, if you read the book, it's quite expensive because last time I was talking about it, a student was like, oh, I'm gonna buy it, and he looked for it on Amazon, and he was like, oh, it's too expensive, I'm not gonna buy it. But I think it's good to invest on your education, to invest on the intellectual part. Okay, so if you're interested in Japanese law is more about law and culture in Japan, so it's quite interesting. I could not provide you with more copies. I know that it's interesting, but if you continue reading, it mentions about the Japanese tradition of suicide, so whether it has to do with this or not, you can see here it says, we have decided to apologize with our lives, which maybe would not happen in Western societies. And you can also see some amounts which are quite shocking. So it's $200, which would be yes, around 20,000 yen. So $1,500 would be around 15,000 yen, 100. So you see that there should be no society where people are committing suicide because of such amounts. And here we have 3 people committing suicide. Now, regarding money lending, we have 3 pieces of legislation, 3 main pieces. The first is the Money Lending Business Act. The second, if you check page 2, is the Interest Rate Restriction Act. And there is also a third one which we will talk about during these parts. So let's start with the Money Lending Business Act. It regulates the business activities of money lending businesses by first creating a system for registration. That means in Japan, if you want to start a money lending business, you have to register. And after you registrate, you have to renew your registration every 3 years. There is also a supervision by the administrative agencies. First, they can collect reports and also conduct on-site inspections. Second, they can suspend businesses or rescind the registration according to necessity. And third, they can give orders to businesses for an improvement of the content of their business. So, this is the first part, registration and supervision. The second part is really interesting. Why is that? It has to do with the regulation of business activities. To be more precise, a regulation on the acts of collection. What does that mean? If you are a money lending business, you lend money, but in order to survive as a business, you also need to collect. To collect the money you have given plus the interest. So that's your profit. There were some situations where people would not be able to repay, like in the parts we read, for many reasons. So, please have a look at the first page of today's provisions. You will see that page 1 and 2 are actually one provision, not even one provision, half provision. Article 21, only paragraph 1 of the Money Lending Business Act. Why did I say that this is interesting? This is a provision which has to do with restrictions on acts of collection. What does that mean? Restrictions on the way businesses collect their money. Why is it interesting? Because usually I tell students that if you check the law of a certain country, you can understand what was happening in that country some years before the legislation was introduced. For example, if you check the Japanese penal code, there is a specific provision. So there is a provision on rape and another provision on rape committed by plural people, by a group. Why is that? Because there was a certain period where there were many incidents of rape committed by a group of people. So they decided to introduce a new provision and punish that heavier. So that's not something which happened by chance. You should be able to read the provisions in that way. So, how should we read this provision? If you check numbers 1, 2, 3, 4, 5, and then second page, 6, 7, 8, 9, 10, you should not think, oh, so this is the content of the restriction, excellent. No, you should think, oh, so this is what the businesses were actually doing. So that was why this was put in the provision. So what were these businesses doing? 1, telephoning or visiting, number 1, during hours found to be clearly inappropriate. For example, late in the night or early in the morning. Number 2, transmitting a message by using a fax or visiting the residence, etc., again, in hours which are not found to be reasonable. So this has to do with the house. They didn't stop there. Number 3, workplace, telephoning or sending messages or visiting the place of work. Why? Because that person would feel ashamed in front of his colleagues, so it would put a lot of pressure on him. Number 4, failing to leave the residence or the workplace. Wow. And he or she is not even a future boyfriend or girlfriend, okay? He's just a business. He or she works for a business. Number 5, disclosing facts regarding the borrowings of an obligor. What's that? For example, they would put pieces of paper a lot of pieces of paper on your house's door saying he owns us this amount of money, he has not given it back to us, you would remove it, and the next day they would again post that on your door, so all the people in your neighborhood would know about your situation. Number 6 on page 2. Request that an obligor raise funds towards, etc. by borrowing money from persons other than the obligor. What does that mean? You cannot give us our money back? No. Well, you can go to another company, borrow money from them, and give us that money back. Yes, but that does not change my situation. I will be just borrowing from another person. We don't care. You have to do that. Number 7. Requesting that persons other than the obligor make performance. What's that? Do you have any brothers or sisters? Yes. Okay, so you know where they live. Please go to them and ask them to give you some money, for example. Number 8, number 9, number 10, so you can see what was happening. So if you combine this information with the information of the book, you have a clear picture of what was happening. So why people would choose suicide as a solution instead of trying to give money back. Nowadays, this is all prohibited. So you can only see it in some movies talking about this old era in Japan. Prohibition on excessive loans. This is the last part of the regulations under the Money Lending Business Act. As I told you, if you are a money lender, the more you lend, the more profit you have. Why is that? Because your profit is the interest. So if you don't lend somebody, there is no interest, there is no profit. So in the past, the companies would not care about your, please underline, repayment capacity. Please underline repayment capacity. So what's that? They would just lend you as much money as you would ask them to do, without caring whether your income allows you to repay. So that's why we were having these situations. Yes? Could you pass the microphone to Carmen, please? Yes, Carmen?
Sorry, even without the regulation, why wouldn't they care? Because they want their money back.
That's an excellent question. Because if you don't have money, you have your father, your mother, your brother, your sister, your uncle, your aunt, your friends, your boyfriend, your girlfriend. You can go to them. And if you have no relatives, you can go to other companies. Otherwise, we will visit you to your workplace every day, we will go to your house every day and night, etc. So, we don't care about your repayment capacity because the way we do it, we, the money lending businesses, somehow you will find the money to repay us. Okay? Not all the companies, but many companies were doing that. That's an excellent question. Any other questions? So, today, money lending businesses have the obligation to investigate your repayment capacity. So if you see here, it depends on the amount of the loan. If the total amount of the loan by a certain business exceeds 500,000 yen, 50万yen, that business is obliged to ask you to submit your withholding records, Gensen Choshu Hyo, from which they can understand what your income is. And if the total amount of your loans from all the businesses, so not only from a specific business, exceeds 1 million yen, again, they have the same obligation. And second, this is something really important, it is prohibited to conclude loan contracts under which the total borrowings of a certain person exceed 1/3 of his annual salary. So that means that according to the statistics, we are usually able to repay an amount which is equal or less than 1/3 of our salary. Usually it's 1/3 for the houses, quite expensive in Japan, rents, 1/3 for everyday living, and 1/3 which we could save but we could also repay. Okay? So this is the content of the regulation today. Do you have any questions regarding the Money Lending Business Act? Because after this we will move to a different act. Yes, Matthew?
Some money lending businesses do have a concept of a deposit, so you leave an item of value with them, like a pawn shop arrangement. Would they apply under this area in terms of showing their ability to repay?
That's a good question. I have to check it. Yes, I'm not sure if they fall under the category of money lending businesses or not. So I need to check it and answer you maybe next week.
Thank you. So
It's a good question, yes.
another thing that just occurred to me, the threshold for lending, generally speaking, you go to a money lender when you can't get a loan from the bank. Now, the bank has its own, the reason it doesn't give you a loan is because you fail to meet certain ability to repay thresholds. I'm curious, I'm not sure that you'll know, but I'm curious about how great a difference is it required for your ability to repay between the bank and this kind of company?
Okay, that's a good question. So in general, we could say that in the past, it had to do with whether you have something which could be used as a guarantee for your repayment to the bank. So usually banks ask you for a mortgage or something similar, and if you cannot provide that, then usually they do not accept. Usually, it also depends on your income, etc. But I agree with you, yes, in the case of money lending businesses or of businesses which are connected to the mafia, the Japanese mafia, they don't care so much about your repayment capacities because, as I told you, they have other ways to collect their money back. So yes, the criteria are more strict when we talk about banks, less strict when we talk about money lending businesses, and even less strict in other cases.
So essentially they wouldn't be required to search your credit history or something like that?
It's part of, I think it belongs to this part, the part of the outstanding balance of loans anyway. So yes, they collect nowadays, okay? Yeah, they do that.
Thank you.
Okay, thank you. Any other questions? Yes, Kami?
Sorry, because I just watched this movie about the medieval things that usury is illegal, so they make like a bond thing. So is it like also like it's not an interest, but it's like more like the interest and the principal become higher. Is it the same thing? I think they pay.
Okay, in this case it's an interest, but there is also that method and tactic, and we will talk about it later. Okay, yes, that's a good question. Other questions? Okay, thank you for the very interesting questions, and let's move to the second piece of legislation. Interest Rate Restriction Act. So, this is the central act regarding interest rate restriction. Who would like to read Article 1 of the act? It's on page 3. Yes, please, Yuki.
Article 1 is interest under a contract for interest on a loan of money exceeds the amount of calculated based on the interest rates specified in the following items in relation to each of the intensives. The reference in the following items, the contract shall be void in relation to the portion of interest which exceeds those respective amounts. 1. Where the amount of the principal is less than 100,000 yen, 2% per annum. 2. Where the amount of the principal is 100,000 yen or more but less than 1 million yen, 18% per annum. Or 3. Where the amount of the principal is 1 million yen or more, 15% per annum.
Thank you very much. So, this is maybe the most important provision in Japanese legislation regarding money lending and interest rate restriction. You have here the principle in Japanese ganbon, the interest, and the liquidated damages about which we will talk later and which have to do with your question, Calvin. So, let's start with the interest. You can see that the smaller the amount is, the higher the restriction is, but usually most cases will belong to the third category, 1 million yen or more. So the limit is 15%. Now, this has to do with civil law. What's that? Two issues. You can see that it says the interest rate restriction is mandatory. What does that mean? Who would like to answer? You know about mandatory provisions and... Okay, I know that Matthew has raised his hand, but I would like to wait a bit for maybe somebody else to explain us the difference between mandatory and non-mandatory provisions. 5, 4, 3. Okay, thank you. So please pass the microphone to Ken. Your name is Ken, isn't it? Yes, okay, excellent. So, Ken, here it says that the interest rate restriction is mandatory. What does that mean?
So mandatory restriction is that we have to complete the restriction, so we can't violate the provisions.
Excellent, thank you very much. So, let's say that you are, all of you, you are money lending businesses and I don't have money, so I want to have some money from you. And you ask me, so you tell me, well, we should set the interest rate. And you propose 15% because I'm borrowing 2 million yen. And I tell you, you know, my parents were always telling me, you should be an honest person. You should give back what you have borrowed. So you're helping me a lot. I would like to have a higher interest because I appreciate your help. How about 100%? So you're like, are you serious? Are you kidding me? I'm like, no, I'm really an honest person. So I think that 15% is too small. Let's agree on 100%. So you're like, of course, yes, thank you. And I'm like, oh, thank you. So you asked me to put my signature. I put my signature, my income. I have an income which says Kara is Kosu in 6 katakana letters. I also put everything, my address, I give you my IDs, copies, etc. And we shake hands and we say 100%, yes, 100%. As Ken told us, this is not valid. Even if we both agreed, even if I suggested that it should be 100%. It's a mandatory provision, which means that we cannot change it, which means that even if we agree otherwise, the agreement is illegal or void, not valid. Regarding the part which exceeds, please be careful. Please have a look again at Article 1. The last part before the numbers says, the contract shall be void, muko, in relation to the portion of interest which exceeds those respective amounts. So, If I tell Ken it should be 100% and we agree, automatically it becomes 15%. Okay? The part which exceeds is void. Second issue. Okay, let's have a 5 minutes break and we'll continue after the break. If you have any questions, feel free to ask. Okay, let's start with the second part. So, I'm sorry for interrupting you. I was saying that this has to do with the civil law part. What does that mean? Let's have a look at this slide, which is interesting. Please be careful. This has to do with the situation before the amendment. So this is the situation which was creating all these issues we were talking about, suicide, etc. But it's something which has to do with Japanese culture, Japanese history, Japanese society, so you need to know this. So, the green part is the part where the contract for money lending is valid. Depending on the amount, the rate can be from 15 to 20%. If you have a look, it says 29.2% and above. Penal punishment. What does that mean? Please have a look at today's provisions. Who would like to read Article 42 of the Money Lending Business Act, paragraph 1? Yes, please, Eliko. So, half to Eliko, half to Lily. You decide which half. It's quite long, it has 6 lines. I really like when people negotiate. It's better than doing janken, okay? You develop some skills, okay? Yeah. So, sorry, please.
With regard to a contract for monetary loans made by a moneylender on a regular basis, including contracts where money is to be delivered based on a discount of negotiable instruments, security by sale, or any other method similar thereto.
Where a contract for interest whose interest rate exceeds 109.5% per annum, in the case of a leap year, such interest rate shall be 109.8% per annum, and the diem interest rate shall be 0.3% has been concluded. Agreed liquidated damages for default shall be included as interest. Said contract for monetary loan shall be void.
Thank you. So, please be careful. This provision says that if we have a monetary loan with an interest rate exceeding 109.5%, the said contract is invalid, void. So, this is the part here, contract invalid. This has to do with both money lenders and natural persons. So, even if I, as a person, as an individual, borrow money from Chisaki as an individual, both individuals, not businesses, this applies. If we agree an interest rate which is 109.5% or more, our contract is void. So this is the limit for all of us, in all cases. What's the other provision? The other provision is on page 4. Act regulating the receipt of contributions, the receipt of deposits and interest rates. I need 3 students, 1 for each paragraph. 3 students, 1 for each paragraph. 3 students, okay? So let's start with Kelsey, and then we go to Matthew, and then to Chisaki, okay? Kelsey, paragraph 1, Matthew 2, Chisaki 3.
Article 5(1). If a person lending money has formed a contract to receive an annual interest, including an amount of liquidated damages for failure to perform an obligation, the same applies here and after, exceeding 109.5% or 109.8% in a year that includes February 29th, at a daily interest exceeding 0.3%, he or she is subject to imprisonment with work for not more than 5 years, a fine of not more than 10 million yen or both. The same applies for a person that has received or demanded interest in excess of this rate.
Thank you, Kelsey. So please be careful. This provision says that if a person, which means that it does not have to be a business, lends money and the interest agreed is 109.5%, as we saw in the other act, it's invalid. Plus, we have penal punishments. Okay, that person can even go to jail. Matthew, paragraph 2. Thank you. You're all so kind. You don't throw the microphone. That's really nice. Thank you very much. Okay, so Matthew, paragraph 2.
If a person lending money as a business has formed a contract to receive an annual interest exceeding 20%, he or she is subject to imprisonment with work for not more than 5 years, a fine of not more than 10 million yen, or both notwithstanding the preceding paragraph. The same applies for a person that has received or demanded interest in excess of this rate in connection with the loan.
Thank you. So, please be careful. Please be careful. This paragraph talks about businesses, money lenders as businesses, and it says 20%. This is the current provision, the currently existing provision. In the past, it was 29.2. In the past, it was 29.2. So, in the past, if a business agreed on a money lending contract with an interest rate of 29.2 or more, that business would be punished according to the penal law provisions. And finally, paragraph 3.
If a person lending money as a business has formed a contract to receive an annual interest exceeding 109.5% or 109.8% in a year that includes February 29th, at a daily interest in exceeding 0.3%, he or she is subject to imprisonment with work for not more than 10 years, a fine of not more than 30 million yen or both, notwithstanding the 2 preceding paragraphs. The same applies for a reason that has received or demanded interest in excess of this rate in connection with the loan.
Please be careful. What happens here? So, we said that in the past, 109.5% the contract was invalid for everyone. Penal law punishments. If it's an ordinary person, 109.5 or more, there was a penal punishment. If it was a business, 29.2%. Now it's 20, but before that it was 29.2 punishment. And if it was a business lending at an interest rate of 109.5% or more, you can see that the punishment was more severe. You can see that the amounts of the penalties or the duration of imprisonment was longer or larger. So, what was happening in the past? In the past, this was 29.2%. Now it's 20, which means that if you are a money lending business connected to the Japanese mafia, you know that there is always a way for a person to find money because they're afraid of you. So, you know that if you agree at 29%, that the contract is void under the civil law. But you don't care because you know that they're too afraid to go to the court. So the only thing you care is that they don't go to the police. That's bad for you. So you agree on an interest rate which is within the so-called in the past gray zone. Now, if you agree on an interest rate which is in the past, in this gray zone, the contract is void, but you don't care so much. And they cannot go to the police, which is excellent for you, because there is always a way for them to find money if you are connected to the Japanese mafia. Plus, this. Oh, sorry, not this. Plus, this, the first part. In the past, there existed a provision which was saying that if you repay an interest which is higher than the restrictions, that means which is within the gray zone, please put a circle around voluntary. That payment would be treated as legal and valid. What does that mean? Okay, so I see that many of you are like, what's that? You can easily understand that the money lending businesses have a lot of power and a lot of money, so they can influence the politicians. So the politicians need to be strict on them because people are watching, but they also need to be kind to them because money is flowing sometimes from there. So what do? You restrict the interest rates, you also impose penalties, but you accidentally leave a gray zone. Oops, we did a small mistake anyway. And you also provide that, well, if it's an interest rate within the gray zone and you repaid voluntary, then it's valid. It's not invalid as it's supposed to be under the civil code. So, you can easily understand that if you have borrowed money, you are in need of money. So, if nobody is lending you money, as Matthew told us, because the banks have stricter criteria, you go to money lending businesses, they ask you, would you like to agree 25%? You will be like, yes, because nobody is lending me money. And you sign some papers saying that I agree to that, and when you pay back, you also sign some documents saying, I know that this is invalid, but I still want to pay that. So it's the situation between Chisaki and me I was telling before, okay? I'm an honest person, I understand that this is invalid, but I still agree to pay. So it suddenly becomes valid. So now you have a very clear picture of what was happening in Japan during that period. Because if you don't know that, you don't understand why were people committing suicide. Why? Well, this is the reason why. Because they would force sometimes to agree on an interest rate within the gray zone. The police cannot interfere. They could interfere only if it was 29.2% or more. But of course, money lending businesses are not stupid, so they would not do that. And you know that it's invalid, but if you agree to pay it voluntary, then it suddenly becomes valid. So everything is clean, everything is legal, nobody can interfere. Now, the provision that you read, page 4, paragraph 2 of the provisions, you see that it says 20%. So nowadays, there is no gray zone because the limitation under the two acts is the same. Plus, this system of the voluntary repayment has been abolished. The provision has been erased, deleted. So nowadays, we don't have the gray zone. It's 20% also for the penal punishment. I know that you are all very clever, so you would think, no, there is a gray zone. If you borrow 1 million yen or more, it's 15%, but the penal punishment is 20%, so you still have a gray zone. But no, you don't have a gray zone because the system was abolished. So if you know that it's void, you can go to court and say, I'm not repaying, it's void. Which you could not do in the past because they had this system of voluntary payment. So nowadays, there is no gray zone. That's how the situation has changed. Any questions regarding this? It's a bit complicated, maybe difficult. Is it clear enough? I also accept questions in Japanese if you don't want to make questions in English. I'm not talking about you, okay? The others. Okay, now let's go back to Kelvin's question. So, your question was, there is a part which skipped. Please have a look again at the Interest Rate Restriction Act. Who would like to read Article 4 of the Act on page 3? Yes, thank you. So please pass the microphone to Kelsey. Oh, I thought you were... No? Okay,
I'll still
so
read it if you want, but...
it's... okay, let me check. Mistaken belief on my behalf. but in this case, I think your manifestation of intention is valid, so please pass the microphone to her. Don't do that with your friends, okay?
Article 4.
Yes, it's on page 3, Article 4 of the Interest Rate Restriction Act.
Okay, got it. If the ratio of liquidated damages to the principal under an agreement for liquidated damages due to a failure to perform an obligation under a loan of money exceeds 1.46 times the rate prescribed in Article 1, the agreement shall be void in relation to the excess portion.
Thank you. So, it talks about liquidated damages. So, Carmen, what was happening was that some companies would agree on a low interest rate, but would provide a very high rate for liquidated damages in case you don't repay during the agreed period. So they would say that's not an interest rate, it's liquidated damages. But you see that also that is regulated. And in general, the courts are really careful. They check maybe that's an interest rate, although you're saying it's not. So there are not so many ways to escape that. Okay. Any questions? So, okay, yes, Carmen, could you pass the microphone? Thank you. I'm sorry for this. Thank you.
Thank you. I'm sorry, I'm not very clear about 1.6 times the. Can you give an example? Like I borrow $1 million and then 1.6 times.
Okay. So the interest rate in the middle is the amount you have to repay on the agreed date. So you repay the principal plus the interest. If you are late, if you don't have the money on that day, they usually ask you to pay also for liquidated damages. That's kind of a penalty, private penalty. And they would say that's not an interest, it's liquidated damage, which means that it does not fall under the restrictions for interest, so we could agree 100% or maybe 50% or something. So this provision says that depending on the amount, there is also a limit for liquidated damages, which is 1.46 times the rate written in the middle. So if it's 20, it becomes 29.2, etc. Okay? Any other questions? Okay, so let's move to the last part of today's lecture. So, there was a period during which, if you would check the internet, you would find a lot of advertisements of law firms, lawyers, asking you to contact them because they would be able to get back the amounts you have paid in excess, so the amounts which are supposed to be void. You can see here that, for example, this advertisement, which I found on internet, it does not have the name, etc., so it's okay to use it, I think. It says that we will do the calculation for 0 yen. So you come to us, you will give us all your papers, how much, because usually it's quite complicated. You don't borrow at once. You borrow one amount, then after 3 months another. Sometimes the rates are different, so it's very complicated. They will do the calculation for free. And if there is an amount which exceeds, then you can ask them to take it back. And I found a lot of advertisements which were saying that usually we receive 20% of what we take back, but now we can just take 15%, it's special agreement, etc. So, it was a bubble. There was a period where lawyers could make a lot of money by doing this business. Why? Because there were so many money lending businesses which were lending in excess of the interest rate restriction. I have a friend who is a lawyer in Tokyo, female lawyer. She is working in a small firm, and her boss lawyer owns the building. It's a 5-story building. And she told me that, oh, he bought that building thanks to such cases. There were so many cases of money lending that he was earning so much money, and he actually, within a year, bought the whole building in which he has his office now. Nowadays, according to my friends who are lawyers, the bubble does not exist anymore because now things are more legal. The next bubble is the hepatitis cases. As you know, in Japan there were some cases of injections by the state about some certain diseases, and many people got hepatitis due to such injections. And now you will see a lot of advertisements on TV or on internet asking you, you can contact us if you've got hepatitis due to such injections, vaccinations. It's the next bubble, according to my lawyer friends. So they can make a lot of money thanks to that. When that goes, maybe they will find the next bubble. I'm not blaming the lawyers because, as you can understand, it's money which was going illegally to money lending businesses. So they just took that back and just retained a portion of that. So it's not something which is illegal. But you see how the economy sometimes functions. And you see that this is the part I would like you not to forget in the future. We sometimes talk about economy, finance issues, etc. But in the background, there are people committing suicide. So it's not always, all the losses and the economy is moving and we are making money, but it also has to do about human lives. So we should not forget that. It's not everything about economy, finance, law, no. It's about human lives too. Now, 2 last slides for the procedures for persons with multiple debts. This is also something Japanese. So, please have a look again at the last page, the copy from the book. If you check again the first page, second paragraph, first page, second paragraph, in the middle it says, in the newspaper, he read for the first time stories about the new legal process called civil rehabilitation. In my slide, you will find it as individual rehabilitation, kojin saisei. What's that? Let's start with the first procedure available for people who have large amount of debts. Adjustment of debts. In Japanese, nin sei. What's that? It's also a good business for lawyers. You go to a lawyer, he makes the calculation, because as I told you, it's usually complicated. Many amounts, many different interest rates, different periods, so you need to calculate, recalculate, etc. And now, before starting, I need to mention that all these procedures have to do with people who are unable to repay, okay? Overdebted. So, you go to the lawyers, they prepare a plan for payment in installments. What does that mean? You are supposed to repay all the debts within this year, but you cannot. Which is bad for both sides, because also the money lending businesses cannot collect their money. So the lawyer makes a suggestion. He says that my client was supposed to repay you within the year, but let's do it a bit in a longer period. Let's do it within 3 years. Please take a note. 3 years, which means 36 installments, is usually the limit. It's not an official limit. It's not an official limit, but usually 36 installments, 3 years, is the limit for the money lending businesses agreement. Usually, if it's longer than that, they say, no, we don't agree. So, please be careful. This is actually a negotiation and settlement procedure. It's not something official. Usually you go to a lawyer, he calculates, he negotiates with the companies, the money lending businesses, and they agree on a different repayment plan. And please be careful, usually 36 months is the maximum. They don't accept longer periods because it's a bit risky. Okay? So, as you see here, we need to have an agreement with all the creditors. Please underline with all the creditors. Otherwise, somebody will ask you to give money back earlier, and this will not work. So you need to have an agreement with all the money lending businesses for a longer period repayment. But, as you understood, this is nothing official. It's just negotiating and making an agreement. What are the official plans? 2. The first is ikohasan, personal or voluntary bankruptcy. Please have a look again at page 1 of the book. First page. Second paragraph. It says, in the middle, but as he read, he learned of debtors who had chosen the new process as an alternative to bankruptcy. He had never considered himself a candidate for bankruptcy. That would only make his life more miserable, and it was miserable enough as it was. So, what happens in case of a bankruptcy? Usually, again, you go to a lawyer, and here, you lose all your property. Why is that? They sell your houses, your cars, etc. Try to repay with the money collected your debts. And usually it's not enough, because if it was, you would not go into bankruptcy. You would just sell your house and cars and repay. So you receive an order of grant of discharge regarding the remaining part. In short, you just repay part of the debts by selling all your property. That is done usually by a lawyer, so there is a lawyer who controls this, manages the process. You lose all your property, but you also get a grant of discharge, so you are relieved by part of your debts. And you can restart from zero. Sounds nice, but as you saw in the book, Mr. Kazuyoshi Saito was not so willing to do that. Why is that? Because it doesn't sound so nice. That's the first part. Bankruptcy, in Japanese, hasan. And as you know, in Japan, we care more about what our neighbors think about us, what the friends think about us, and we wouldn't like to say maybe that I wouldn't care. But anyway, an average Japanese maybe would care. And the second issue is that there are qualification restrictions. There are certain professions, etc., which you cannot exercise if you have gone to bankruptcy. For example, you cannot work in a patrolling company, a security company, a company which provides security services if you have gone into bankruptcy. So, as we saw in the book, same as Mr. Kazuyoshi Saito, most people would be more interested in Japan to use the procedure for individual rehabilitation. This is really nice and useful, and a bit Japanese. What happens here? If you have a total debt of 50 million yen or less and a stable future income, for example, me here, I have a stable future income unless I do something really wrong, and if my debt is 50 million yen or less, and if I cannot repay it, I apply to the court, my debt is reduced to 1/5, 20%, and I pay that in installments of 3 years in principle. Ooh, so nice. Of course, in some cases, you cannot apply for this, but in most cases you can use it. So, here's what happens according to a Japanese small manga. Your debts are reduced to 1/5, and you just have to repay that within a period of 3 years. And there are a lot of advantages because you can keep your house, you can keep your car, and you can work in the positions which you wouldn't able to do if you went into bankruptcy. So this is the perfect way for a person in Japan to cope with his debts. And finally, we have the specified mediation, which is an official procedure, but in fact same as number 1. So you negotiate and settle, but this time you have also some people who manage this procedure. So it's an official procedure, but still you have to negotiate and settle. So 2 and 3 are the best solutions, and as you can easily guess, in most cases it would be 3. A small addition. I have a friend who is a lawyer in Tokyo, and he is having, you cannot go into bankruptcy if you do that intentionally, which means that you borrow a lot of money, you go to Bahamas, you go to Hawaii, you buy whatever you want, you spend the money, and then you say, sorry, I go into bankruptcy. In that case, you will not receive an order of grant of discharge, and also you will not get an order of grant of discharge if you have money saved somewhere. But that friend of mine was telling me that he knows many presidents, owners of companies who do that. They keep some money inside and they say, okay, I will go into bankruptcy, I don't care about how people think of me, and I will be relieved of my debts, and then I can restart, but I still have the money, so I can easily restart, etc. So you can see that it's a difficult issue where to set the limits. Always, such systems are supposed to protect the weaker, but sometimes they are misused by the stronger. There is always that dilemma. Any questions regarding this? Yes, Kanami?
It's the same stigma applied for business bankruptcy. because I think it's a very calculating process. Right?
Okay, you mean cases of businesses doing, not individuals?
I think this is for individual.
Yes,
I
this
know.
is personal, yes.
For the culture part, I mean, do you feel ashamed?
No, I don't think that in case of businesses there is such an issue. It's mostly about people doing this personally. So, yes. So, Caroline, that's a very good question because I forgot to mention that you see how the names are different. Here you have personal or voluntary bankruptcy, Jikohasan, but here you suddenly rehabilitate, individual rehabilitation, which sounds really nice. So it was like in the Juvenile Act, if you remember, where you have somebody who is a juvenile and has committed a crime, but you need to correct his personality, etc. It sounds really nice. So sometimes people react to the titles and the names. So if something sounds a bit nice, and it's easier for them. And this was of course necessary because you saw what the situation was in Japan before, many people committing suicide. So yes, this was necessary, but there's always a but. Any other questions? Yes, of course, come in.
Sorry, for one more question. Okay, for the suicide part, I want to ask, like, is it because, like, now the people who used to, now they cannot get the loan that they need, or so they will go suicide. They cannot say cure their daughter from expensive these things or that thing. So in the end, the problem still exists because they don't have the money. So they will suicide anyway. I think it's just moving the problem.
Oh, you mean in the past or nowadays?
Nowadays,
Nowadays,
as if it solves the problem, but I don't think that, because if you don't, you borrow that amount of money because you don't have the money in the first place, and then back then you have the loan, but now you don't have the loan, so now you don't have a lot of debt, but you cannot solve the problem that you solved the loan before.
Well, I think now the situation is easier because you have all these restrictions, especially here, the prohibition on excessive loans. You have these restrictions and you have these procedures. So I think nowadays the situation is a lot better. Of course, there might be some extreme cases, but in general, we could say that it's a lot better. So.
I mean, because now it's very hard to get loan, and as a creditor, it will be riskier to give loan to you. So instead, I will not give you loan in the first place. So you will still have the problem that will cause the suicide.
Yes, I agree. So if you read Japanese newspaper or if you watch TV programs, they mention a lot about the issue of poverty in Japan, which is growing larger, and that's another issue. And I agree. Yes, maybe the situation will move to a different level. Any other questions? So, see you next week. We will talk about something also interesting. And if you have any questions, feel free to ask.